the top of the hour, and I wanted to start our WAITS webinar. Today's topic is the Volcker Rule, past, present, and future. I wanted to thank everyone for attending and welcome you. My name is Jenna Ellis, and I am one of your moderators today. Mainly our moderator is going to be my colleague Dan Tatello. I wanted to let you know for all the attendees, if you have questions for our experts during the session, or if you're having any problems, you can use the chat feature, and it's at the top of your screen. If you just drop down and select the chat icon, and then when it says send to, drop down to my name. It's Jennifer Ellis on this webinar, and send me a chat, and we'll do questions for both Amy and John at the end of our session. So if you have any, please feel free to type them out via chat for me during anytime you can think of them during the webinar. So with that, I wanted to introduce our experts today. Let's see. We have two great experts. We're lucky to have them. The first one is John Pekowski. John is an attorney and senior banking analyst at Wolters Kluwer, and he's worked for over 25 years and has over 25 years of experience tracking and explaining banking developments for the federal banking law reports and the Banking and Finance Law Daily. So welcome, John.
Thank you, Jenna.
And then we also have Amy Leisinger. Amy is a writer-analyst also for the Securities Group of Wolters Kluwer Law and Business, and she is a regular contributor to the Securities Regulation Daily, which I know many of you read, as well as the editor of the Mutual Funds Guide. She also contributes to a suite of securities law products, including, of course, the Federal Securities Law Reporter. So welcome, Amy.
Pleasure to be here, Jenna.
Thanks, Amy. So with that, I'll turn it over to Dan to describe or to give you a little bit of an overview of the Volcker Rule webinar and some of the topics we're going to discuss. So Dan, take it away.
Okay, great. Thanks, Jenna. And again, thanks everybody for joining the webinar today. We have a lot of content that we want to cover, probably in a question, mostly, in a question and answer format over the next about 30 minutes or so or less. We'll be sure to get you out of here right on time. But we definitely wanted to make sure we highlighted what the white paper was. That really has a lot of these issues in here. And then, of course, we're going to expand on some of the issues. So on the left-hand side, you'll see we wanted to start by talking about, under the Volcker Rule, some of the unintended consequences, and some of the things that were answered by the FAQs that the agencies have put out, and kind of the nature of those FAQs, as well as some a speech made by Commissioner Stein recently about maybe implementing a process for those. But also talk about legislative developments that include the Shelby bill and some other aspects of the Volcker Rule, and then just some information about looking ahead. So that's an overview of where we wanted to get to today. And as Jenna said, we are going to try and leave some time at the end for any questions if you send them in via chat, or just open it up at the end and we'll see if you have any questions. But also, a lot of times people will ask on the chat, are we going to send out the slides or any of the information? We absolutely will send the slides, as well as this white paper that we'll reference a few times, at least a link to it for everybody to access. So that's our introduction, and with that said, one of the first things that we were looking to discuss today are the unintended consequences, and I guess, John, I think we have been talking about that, some of the unintended consequences, including issues around the trust preferred securities issue. And then I know that one got resolved, but I guess that's one of those unintended consequences that came up with the Volcker Rule. I don't know if you wanted to start with some background on that issue.
Well, the trust preferred securities issue was probably the first unintended consequence. Shortly after the agencies issued their final rule in December of 2013, banks and their bank trade associations asked the agencies, please, we're having trouble trying to get these trust preferred securities to be in conformance with the Volcker Rule, or they may fall within the Volcker Rule because of certain ownership characteristics. So as I said, there were some letter writing by the banks, by the bank trade organizations towards the end of the year, not seeing anything that's going to be resolved quickly. The American Bankers Association, with a number of banking institutions, filed suit seeking to have that portion of the Volcker Rule enjoined in federal court. And basically the agencies in early January 2014 came out with a final or an interim rule, it's never been finalized, spelling out what types of trust preferred securities will not fall within the definition of a covered fund. And they actually gave a list of covered, of the types of what they call true trust preferreds that would not be considered covered funds. Eventually, the ABA and the banks dropped their suit, and that's basically that first unintended issue. That's where we stand with that one.
And so that one, and that has led to some other issues. But one of the one of the things that you had talked about was the FAQs are one of the ways that people are getting some of their answers. That's been a real issue for practitioners, I guess, as far as anticipating with FAQs. Is that true, or?
Yes, it seems like they just come out of the ether. I mean, you have to be very studious. You have to keep checking the agency's websites on a periodic basis. You have to know where to look. The Federal Reserve Board, is good at posting them on their What's New web page, so you know that they're pretty much available when they issue a new one. But they just come out of the blue, basically, and they just started doing that, I think, June of last year, and they're up to about 13 as of, I think, February of this year, 13 different FAQs covering a number of subject areas. As I said, they just come out of the blue. I see them. I check the websites for my work with the Federal Banking Law Reporter, and I also have some different alerts, and I'll see the law firm popped up doing a client alert about one as well. So sometimes that keys me in as well. But there has to be perhaps a better way that these FAQs can be coming out. Amy, I'm pretty sure I read something recently about Commissioner Stein. She had a proposal recently or earlier in the year. Can you elaborate on that?
Yes, actually just last month, SEC Commissioner, just to clarify, Kara Stein, was discussing the Volcker Rule in a speech in Tokyo and actually made reference to exactly what you're talking about, how one of the largest issues surrounding the Volcker Rule is the actual implementation and the confusion that can arise from these, like you said, the FAQs that just sort of come out of the ether. She acknowledged that implementing the rule is complex because the rule itself is rather complex, but regulators cannot possibly address in that original rulemaking every possible question that could arise. But she said that regulators do have a duty to be responsive and transparent when they're implementing the rule, hence the reason for all of these FAQs. Oh, but she also said that implementation shouldn't be delayed just for the purpose of answering every single question. So she said what the regulators need to do is be able to provide meaningful guidance and answer questions, especially in a timely manner, especially as we're getting close to the beginning of real compliance with it. She even suggested the Volcker Rule working group consider establishing a deadline to say whether or not they will answer an industry question, and then to set another deadline for when they will go ahead and answer it. According to the commissioner, this kind of clarity is really important because this is how the industry is going to comply, and if this financial reform will have its intended effect of creating resiliency and enhancing industry interaction and protecting retail banking customers, these kinds of specific decisions need to be made.
Okay. I mean, yeah, so the idea of that is to be able to try and, give a little more transparency as well, I guess, expectation of what's coming.
Correct.
Being the goal. But as far as the FAQs that are out there, is there one in particular that you think is valuable to talk about as far as an example of some of these FAQs? I know, like, the SOTUS example was in your white paper.
Right. I mean, that was the latest one, and I think just because it covers the international aspects of the Volcker Rule and what they call the extraterritorial reach. And it was a fairly narrow issue about how this situated outside the United States marketing restriction applies to foreign banking entities. Basically, this SOTUS restriction states that you cannot offer, some foreign banking organization cannot offer a covered fund to a United States citizen. This FAQ dealt with a narrow issue where this foreign banking entity actually invested in a third-party covered fund, and how the SOTUS marketing restriction would apply to that. And it was the staffs of the agencies basically said the restriction applies to the third party and not to the foreign banking entity investing into that third party fund. So that's where, at least dealing with extraterritorial reach. Now I see you put up another unintended consequence dealing with international issues that got some play in the press a couple of weeks ago. The Canadian Finance Minister, Joe Oliver, was speaking at the Securities and Industries SIFMA, the acronym, at a conference in New York City, and basically said the Volcker Rule may violate NAFTA. So, there was just a play. That was basically all that was mentioned in the press, and nothing much else about it. And actually trying to write about this myself for our Banking Daily, I actually went back and looked at some of the comments from Canadian stakeholders that were sent during the regulatory process, and a couple of them did raise the issue that certain aspects of the proposal may violate NAFTA because we aren't giving equal treatment or national treatment to Canadian banks to come into the United States. Now, some of the issues I think were resolved when the final rule came down, and they primarily dealt with different types of government-issued securities or instruments. So basically, as I said, that's where it stands now, and it's out there that, violates NAFTA, Volcker Rule may violate NAFTA. The Treasury Department, right after that comment was made, in an email to the press said, no, it doesn't. And just last week, again, just in the general press, Joe Oliver said, we're not really going to press the issue right now. So that's,
right.
On the international side, that's another one of those little unintended consequences that may pop up from, going forward.
And you were saying, even during some of the proposed phases initially, there were some of these issues about international that had come up, and, like this, where they said they decided not to press it. And I don't know, Amy, I mean, you had been talking about some other considerations, as we move forward, that there may be some more international kind of considerations that may, that need to be taken into account. Is that true?
Well, that's actually another aspect of what Commissioner Stein was addressing in her speech, that the world is full of a number of jurisdictions and a number of different regulators who may come up with different solutions to different problems, because primarily the Volcker Rule is a rule in the United States, but as John suggested, it's not always entirely clear what kind of effect this might have on a foreign public fund or even foreign non-covered private funds under the Volcker Rule. While there seems to be at least some consensus as to the reasoning behind the Volcker Rule to be able to kind of put a firewall between commercial banking or retail banking and investment banking for the protection of actual banking customers, it's the approach of various jurisdictions is a little bit different. For example, in the UK, there's much more of a focus on what they call ring fencing, which, as opposed to the divestment, for lack of a better word, that the Volcker Rule causes in these banking entities, ring fencing is creating an entirely separate institution from the bank falling under the same holding company. to separate retail banking activities from proprietary trading and hedge fund sponsoring. In these jurisdictions, they suggest that actually creating these forms of separate corporate governance can simplify structures, decomplexify, if that's even a word, the operations of these holding companies, while allowing people to actually be better able to monitor what these entities are doing. Because it can be difficult to distinguish between what is proprietary trading and what actually constitutes market making. And according to these proponents of this approach, to put them separately together in a distinct entity is an appropriate solution.
That kind of have the ring fencing concept I've always thought has a kind of a similarity to the Glass-Steagall type approach that was like in the 80s.
That was actually another aspect that Commissioner Stein addressed in her speech, that it is kind of a hearkening back to what was happening during the times of the Glass-Steagall Act. But together with the Volcker Rule, these approaches address more modern market risks, new products such as swaps and securitization, or the use of offshore activities in trading.
Okay. Well, I guess transitioning. So transitioning from the international, one of the other unintended consequences that I know we wanted to talk about was the CLOs that came about. And John, I guess we'll pass that back over to you, because these instruments were both given kind of an extension by the agencies, while at the same time, I guess concurrently, now Congress is still taking steps, or at least the industry is proposing that Congress take steps to exempt entities and things like that. I don't know if this is a good place for us to transition over the CLOs and legislation.
Sure. Actually, yeah, the CLOs are collateralized loan obligations. Another one of these instruments that the banking industry relies upon to finance other businesses. Basically, again, it came up shortly after the agency's rules were finalized that the structure of these types of instruments may pose the issue of whether they become covered funds under the Volcker Rule. Just the way they're structured, there's some sort of, you have the power to do something with the manager of the loan obligation, and that shows an indicia of control, which would be ownership. Hence, it'd be covered as it would fall under a covered fund. Again, the banking industry, the banks said, we need relief from this provision. Please do something. So the Fed, in a number of steps, has extended the conformance period. The conformance period for certain activities is July 21st of this year, and that deals primarily with the proprietary trading activities of banks. They either need to be divested or brought into conformance under one of the two exceptions, either the underwriting or the trading desk exceptions. So actually what the Fed did last year was extend the conformance period for CLOs until July 21st of 2016, and they then said, also within this order, we intend to extend it one more year. They haven't said it, yes. They haven't said that they will extend it yet. Everybody is assuming that it's going to be to 2017. My feeling is the Fed's probably, they said they intend to, they're probably going to issue another order or a statement, as they call it, probably within the next month or two, probably mid-June, early July, saying, yes, it's only going to 2017, and that's as far as we can go under the language of the Volcker Rule. Now, last year, Congress also took the issue up, where they would have extended the conformance period beyond 2015 and to 2017 at the time. This legislation was approved by the House of Representatives towards the end of the 113th Congress and, well, 113th Congress ended, it was actually brought up again earlier this year in January. The House passed a jobs creation bill, which was a hodgepodge of different bills from last Congress that were all put together, and this one piece of legislation was included. And this time around, they would not exempt, but they would extend the conformance period for certain types of CLOs until July 21st, 2019. So they were going to extend beyond the 2017 that the Fed would allow and go out 2 or more years. The whole reason the industry is looking for this was the fear of a fire sale. They'd have to get rid of all these instruments at a deep discount. The argument is saying is a lot of community banks under $10 billion in assets, rely on these, as I said, to finance businesses, other businesses within their communities, and that they would be really harmed by this. During the debate of the bill last year on the floor of the House, there was back and forth about, whose numbers do you believe? The side pushing for the extension said, well, yes, this is harming community banks. They're going to be harmed the most. Then you have people who are seeking greater reform beyond Dodd-Frank or stronger reform saying, no, this is only benefiting 3 of the largest banks in the U.S. They never really named the 3 biggest banks. I mean, the government considers 8 banking organizations as systemically important that have to have enhanced supervision. But as I said, it's a war of numbers about who's really being impacted by the CLO extension. And as I said, it was brought up again in the jobs bill. This Congress, it passed the House mid-January and was sent to the House, and it's sitting there for this, it's sent to the Senate and it's waiting for Senate consideration. So that's where the CLO issue is at this point. The Fed's going to extend conformance to probably 2017. Congress has a provision that would extend it to 2019. So that's where the CLO extension is at this point in time.
And then legislatively, it's this bill's passed the House, but it's just it's gone nowhere in the Senate.
Right. That's, as I said, I just checked and just basically it was sent to the Senate and it was referred to the Senate Banking Committee, and the Senate Banking Committee has not taken up anything with that yet.
And then kind of something related, but I don't have a slide for it, but kind of a related bill that I know you've been following was, I don't know if it was just this week or last week, the Shelby bill was something from the Senate.
Yes, Richard Shelby, the chairman of the Senate Banking Committee, issued a draft discussion, what they call a discussion draft, basically what the committee will consider before they send it to the full Senate. And it was deemed a regulatory relief bill. Fairly extensive regulatory relief bill. The Senate Banking Committee considered it in a markup hearing last Thursday, the 21st, and it passed along committee lines. The Senate Democrats on the committee floated their own alternative, which was much narrower and really addressed just community banks. What we're calling the Shelby bill does cover one provision will exempt community banks, those banks below $10 billion in assets, from the Volcker Rule in its entirety. And that asset threshold would also be adjusted on a yearly basis. So, again, it passed out of committee. It's sent to the full Senate. There was some write-ups about it in the media that since the Democrats were strongly opposed to it in committee, that there would be a difficult time to peel off some of the moderate Democrats in the Senate so the Senate can get 60 votes to invoke cloture so they can further debate the bill going forward. One of the senators on the committee, Mark Warner, of Virginia during the markup hearing, in his statements that he was going to use every tool that he learned in the Senate so far to make sure that Shelby's bill does not see the light of day in the full Senate. So that's where we stand legislatively with Congress. Just like last year, nothing happened.
Nothing happened. Well, so those are things that it sounds like we'll be following, as analysts, taking, kind of seeing what happens with either of those bills. It sounds
Correct.
Like we're looking forward. And you brought up something interesting in just the last couple of minutes we have, because we're running a little behind, but I know you talked about anti-evasion, and one of the other things that you just brought up was about, the threshold being at $10 billion, but it would be adjusted. You had talked about both the anti-evasion and kind of maybe the warning a lot of practitioners have said about not playing cat and mouse or using regulatory dialect. I don't know if you kind of want to just summarize some of the ideas about the anti-evasion and some of the things that people are preparing, or practitioners are preparing for compliance.
Sure. Well, basically, we're getting closer to fuller compliance with the Volcker Rule. So the agencies are going to start looking at how the banking agencies are acting, and this anti-evasion provision within the statute and the agency's regulations basically say, these activities cannot evade the requirements. How the agencies are going to go about it, nobody really knows. I mean, my white paper did mention an inkling of how how the agencies may act. One of the law firms put out a client alert that was written up in the paper. But basically, if I recall correctly, there are no real penalties involved. So we were discussing this earlier before the presentation. Probably what will happen is the banking agencies in particular, will use their enforcement powers under Section 8 of the Federal Deposit Insurance Act, which probably, they find a banking entity violating some provision of the Volcker Rule, probably enter into a written agreement at first spelling out to the bank, don't do this, correct your behavior, and, have a program in place to ensure that it doesn't happen again. And then they'll step it up if something happens where the bank breaches some terms of that written agreement, and it would probably go to some sort of administrative proceeding that eventually could lead to a cease and desist or a cease and desist order, and quite possibly imposition of civil money penalties. So that's probably how the enforcement provision, or how the agencies will enforce the Volcker Rule going forward once implementation and compliance is up and running. The other thing you had mentioned was this concept of regulatory dialect. This was brought up last year, actually, in an analysis piece by an individual out of the Federal Reserve Bank of Atlanta, where what happens is an agency is required to adopt the rule. They do so. The industry being regulated looks at it, and then they start pushing their activity toward the outer edges, and it becomes sort of a cat and mouse game where the agency needs to start catching up to that activity. I had interviewed an attorney from a law firm, Ballard Spar, and I had mentioned about this cat and mouse game, and he said it wouldn't recommend trying to push anything to the edge, and he actually gave the analogy from the 80s with the Section 20 security subsidiaries that banks had, where originally they were at a certain level of revenue where they can do certain securities activities, and over the years the banks were able to get the agencies to up that level from, I think it was 5, and they worked it up, I think, to 25% of revenue, if I'm not mistaken. So that's probably a better course of action than trying to look at something and pushing it to the edge, or trying to, say, for instance, repackaging some sort of covered fund and moving it offshore, because the agencies will look at the activity, it's going to be this usual form over substance type of thing. So that's something what to look at from the enforcement, the anti-invasion aspects of the Volcker Rule.
Okay. And I guess, and as you said, as we look ahead, that these are the types of things, as as the compliance is coming up in 2015. I mean, this year. So
Right.
these will be the things we'll be following. Okay. Well, we ran a little over, but Jenna, do we have anybody who had any questions that we should address?
We don't have any additional ones. We had some, but they were all related to Congress, and I think we covered those pretty well. So unless there are any other questions, and you can always submit your questions. My email address is right up here. If you have any kind of follow-up questions, please email me. And I wanted then to thank everyone, and of course our experts, John and Amy. Thank you so much for being with us.
Well, thank
and
you.
Just to reiterate, Thanks, Amy. Thanks, John. I wanted to reiterate, too, that all of our attendees will be getting an email with the white paper if you'd like to download that. The slides from today, everyone always asks for those, as well as a really, really short survey. And the survey really just helps us create topics that you're interested in for our additional weights webinars going forward. So we'd really appreciate 2 minutes of your time for that survey. So with that, I wanted to thank everyone, our experts and our attendees, for coming on to our What Are the Experts Saying webinar. And with that, have a good day.